Further hearing in the appeal Routier and another against Commissioners for Her Majesty's Revenue and Customs.
Yes, Mr. Stanford.
Good morning, my lady, my lords. At the conclusion of the hearing yesterday, I was asked to concentrate on an issue which we entirely accept is an issue at the heart of this appeal, which is what, if any, what is the difference between the principles that apply when you're looking at transactions as between member states and those that apply when the matters in question or transactions in question concern a member state and a third country. I propose to deal with that, if I might, straight away. One has to go back, of course, to first principles, and first of all, some uncontroversial points, which I made yesterday. If the legislation of a member state imposes a restriction on the free movement of capital, the next question to determine is if that restriction is justified. And on that question, the question is on what ground and is it proportionate? Clear authority that a restriction will be justified if it pursues an overriding requirement in the general interest. And as an example of that, the need to guarantee effective fiscal supervision can be singled out as a matter where a restriction can be justified. It is, however, equally clear a member state cannot claim that a restriction is necessary to maintain effective fiscal supervision, if the application, if it's not needed, or if the restriction is not applied in the same way in directly comparable circumstances. For that, I took you to Velta yesterday. I won't take it to you again, but I just make mention paragraphs 65 to 67, volume 3, tab 31, page 1298. Now, even with the restriction can be justified on the grounds that it is necessary to maintain effective fiscal supervision, it can only be justified if it complies with the principle of proportionality. It must be appropriate to securing the attainment of the objectives it pursues, and it must not go beyond what is necessary to attain it. Thus far, I believe that what I'm submitting to you is not controversial. Equally uncontroversial is that we would concede is that on the authorities, on proportionality, there is a difference in how the principle is applied as between matters and transactions between, on the one hand, a member state and on the other hand, other member states, and as between a member state on the one hand and third countries on the other. Just to avoid confusion, for these purposes, the members of the EEA, which have not entered into mutual assistance treaties with the member state, are treated as being in the same position as third countries. If you need authority for that, I think I took you to it, but it is at Rambo, a case which I shall obviously be coming to in a little bit more detail, but I took you to it yesterday, at paragraph 63 to 65, electronic pages 1150 to 1151. Now, in the authorities that I went through yesterday, two reasons were given for the existence of a distinction between member states, transactions between a member state and third countries. The first reason given was that relations between member states take place against a common legal background characterized by the existence of community legislation, such as Directive 77/799, which lay down reciprocal obligations for mutual assistance. And even if the obligation to provide assistance is not unlimited, the directive establishes a framework for cooperation which does not exist between competent authorities between a member state and the competent authorities of a third country, where the third country has not given any undertaking of mutual assistance. To get that, just again for your note, I took you to it yesterday, in the Scatterverket case, paragraphs 60 to 61, at pages 1095 to 1096, and it is also set out in the opinion of the Advocate General at paragraphs 137 to 139, at pages 1082 to 1083. In Scattervet, the court, and perhaps this is worth looking at paragraph 62, which is this is in volume 2, the authorities bundle, tab 26. I should have given you that as well, tab 26. And perhaps if we go to paragraph 62 of the judgment, which is at page 1096, and just the paragraph there, which you can read to yourselves. But the point that he's making there is that the documentary evidence which the taxpayer may provide to enable the tax authorities to ascertain whether the requirements under national legislation are satisfied, the community harmonisation measures on company accounts, which apply to member states, allow the taxpayer to produce reliable and verifiable evidence on the structural activities of a company established in another member state, whereas the taxpayer is not insured of such an opportunity in the case of a company established in a third country, which is not required to apply those rules. So those are the two reasons that have been given. And the result of that is that legislation which imposes a restriction may in any given case prove to be proportionate as regards relations between a member state and another member state, between a member state and a third company, when it is not proportionate to apply that legislation in a transaction as between member states. Now, the prime example of that difference can be seen in the court's approach to the same legislation in issue in the ELISA case. I won't take you to it, but it's at volume 565, page 2101, where the legislation, you may recall, which was anti-tax avoidance legislation, which imposed a tax of 3% on companies, corporate bodies, holding immovable property in France. It was imposed to prevent French taxpayers seeking to avoid or evade the payment of wealth tax on their properties by putting their properties into offshore companies, I can use that expression, companies incorporated outside of the jurisdiction of France, particularly if it was in a country which did not have an exchange of information agreement with France. And the approach to the same legislation in Rambo, which is what I shall come back to, because it's in relation to that the issue crystallises. Now, one asks, well, how, in fact, does that difference in application apply in regard to third countries? And we will submit that what this has meant is that as between a member state and a third country, as a priori restriction, which is the expression that's been used in the authorities to describe it, by reference to a mutual assistance treaty, may be justified if, and only if, there are conditions for the availability of the relief in question which the competent authorities of the member state need to verify, and which they are only able to verify by obtaining information from the competent authorities of the third country in question by means of an exchange of information or mutual assistance treaty. So you may recall Skatteverket and the facts were that a person living in Sweden was not granted exemption from income tax in respect of dividends that were distributed to him by a company established in Switzerland in the form of shares held in a subsidiary in Switzerland. Under the relevant provisions of the Swedish law, an exemption was only to be granted if the distributing company was in a state within the EEA or in a state with which Sweden had concluded a taxation convention with a provision on exchange of information. Although Switzerland and Sweden were parties to such a convention with the avoidance of double taxation, that convention, slightly unusually, did not provide for any exchange of information between the two states. Double taxation conventions frequently, and perhaps normally, do contain a provision for mutual assistance, so that the one country can check for the other country that the tax has been paid if it's to give a credit to it. Now, it was in those circumstances that the court held that the restriction in question might be justified, but only if the national court agreed with the Swedish court's submission that the Swedish tax authorities could not verify compliance with the conditions which were identified by the court at paragraph 64, if you're still on the same page that I was taking you to before, and you can read the next paragraph.
I mean, there seem to be, if you look at paragraph 63, you can break it down into two conditions. First of all, they say, it follows that, one, wherever legislation of a member state makes the grant of a tax advantage dependent on satisfying requirements, two, compliance with which can only be verified only by obtaining information from the competent authorities of a third country, then it's in principle legitimate, etc. And you've been focusing, I think, on the second, what I numbered 2, compliance of which can be verified only by obtaining information. But in the case we're dealing with, isn't there an issue about 1?
Yes, indeed, absolutely. Yeah. In fact, I think that I made that point yesterday. If I didn't, I meant to make it. Yeah. That there are, if you read paragraph 63, there are effectively two conditions that need to be satisfied. First is that the information is needed in order to satisfy a requirement for compliance. That the information which can be verified only by the competent authorities of a third country. So if you have a provision that discriminates, but there is you cannot say that the information that is required in order to see that the conditions are satisfied can only be obtained, and essentially can only be obtained in every case by from the competent authorities. That first condition has to be satisfied. And then the second condition which has to be satisfied is that because that third country is not under any contractual obligation to provide the information, it's impossible, it proves impossible, to obtain such information. And that's, of course, applying the principle of proportionality. Yeah. And of course, that's repeated in paragraph 67, I took you to yesterday. The Attorney General puts the matter, the Advocate General puts the matter perhaps more succinct, perhaps helpfully, and
it's basically 3 requirements, isn't it? Yes. 1 for information, secondly to verify the information, and thirdly that you can't, for whatever reason, actually verify it. It could be because of the lack of a mutual assistance treaty. Yes. But, of course, there would be cases where there wasn't a mutual assistance treaty where, nevertheless, cooperation was forthcoming. Or what you needed to verify was something you could really simply verify from public records, like the death certificate case.
Velta. And in the Cecil case, which was after the Rambo, which I'm coming to Rambo, that was a case where Lebanon had no mutual assistance agreement with think it was Portugal. But nevertheless, it seemed that there was no reason why the information that was required, which is basically has tax been paid or not paid, would not be provided by the Lebanese authorities. And in many cases, of course, where there are, because you have double taxation agreements, for example, which, as we've seen, don't necessarily contain a provision for, as it were, general mutual assistance. And there may be cases there where you don't need it, because perhaps all you need to do is get a certificate from the tax authorities that the tax has been paid, and HMRC will accept, or the revenue authorities in the member state, I should say, will accept that evidence as satisfactory evidence to justify applying a double taxation relief provision in their national legislation. Your ladyship's right, actually. There are three, and I had.
Well, it's just a simple way of looking
when
at
I
it.
looked again,
I like simplicity.
It did seem to me that there were three, though perhaps two main ones.
Yes.
I think the first condition is elided two conditions. That's why we get there. Could I just ask you to look at how the Advocate General put it at page 1085? And again, I think we did look at this yesterday. But if you look at paragraph 153, and the point he makes there is that the, sorry, if you go to page 154, the justification can only be accepted if the member state itself is not able to check compliance with conditions imposed by its domestic law. Clear that the national tax authorities are in a position to carry out such checks using their own resources. The absence of a convention providing the exchange of information does not preclude the member state from conducting genuine and effective supervision of compliance with its legislation. It's perhaps interesting in that regard, having regard to that comment, to actually look at what, as regards Jersey, HMRC, it can be assumed, consider was satisfactory for the purposes of checking information relevant to the double taxation agreement that it has with Jersey, which was in 2009, covering all taxes. Could I just take you to that very briefly? It's in volume 4, tab 50, electronic number 1605. And the interesting point, just to note, exchange of information upon request, this is Article 5.
Sorry, what is this of?
This, oh, I'm so sorry, I should have explained. This is the treaty or agreement between the United Kingdom government and the Jersey government, which was entered into on the 10th of March 2009, and you can see that at page 1596. First. Signed on the 10th March, entered into force on the 27th of November 2009. It's not for the purposes of the application. That has got some relevance to the last issue that was raised, which was timing. But for present purposes, I was simply going to ask you to note paragraph 1 contains a provision for exchange of information regarding essentially all the tax matters which were covered by the arrangement. The arrangement covered essentially all taxes, including income tax, corporation tax, inheritance tax. And if you go to paragraph 5, oh, sorry. Sorry, if you go to we're looking at Article 1. If you see that is the provision for providing the information, and then it's Article 5.1, yes. And then you look at the last sentence of that. The competent authority of the requesting party shall only make a request for information pursuant to this article when it is not possible to obtain the requested information by other means, except where recourse to such means would give rise to disproportionate difficulty. So that seems to be an acceptance by the United Kingdom, at least in regard to Jersey, but we would respectfully submit in regard to Jersey, it could be transposed to any country, and certainly could be transposed to Jersey before this entered into effect, that the only information it actually requires is information which it is unable to obtain by other means. So, just on our case, clearly, it's common ground. HMRC, if Mrs. Coulter had died after this had come into effect.
What's the date of this?
This 2009.
It's 2 years after the date
Yes,
of death of
yes.
the
Yes.
lady.
Thank
Yes. So you're citing it merely
Yes.
as tying in with the EU jurisprudence
It
rather than anything else.
It shows, if you like, a recognition of the proportionality principle in that treaty. If Mrs. Coulter had died 2 years or 2 to 3 years after this treaty had come into effect, then HMRC would have had no need to resort to this treaty in order to get any information, wouldn't in fact have been entitled to, because we know it's quite able to satisfy itself in relation to the conditions for eligibility for tax relief, i.e. to satisfy itself that it was a truly charitable bequest, without recourse, having had any recourse to the competent authorities. Of course, our submission is that you don't need it in relation to the second limb. You don't need to have, in any event, any information from the competent authorities, but certainly in this case, there is none. Now, could I come now to Rambo? We would say, well, let's contrast Rambo. As you will have seen yesterday, Rambo concerned an article of the French tax code, the same one as in Elisa. It provided that legal persons, is the way it's put, which I think is a reference to corporate bodies, were liable for an annual tax of 3% on the value of immovable property in France. Tax did not apply to legal persons with a seat in a state which concluded a convention on administrative assistance to combat fraud or tax evasion. Simply, the point about that being that they could then discover who the shareholder was by that means, and if it was a French shareholder, they would be in a position to say to the French shareholder, right, you're liable for wealth tax if not on the property, you're liable for wealth tax on the value of the shares in this company, because this company holds the immovable property. Now, we know that the Rambo Etablissement was a corporate body established in Liechtenstein, and it did own immovable property in France. And at the relevant time, there was no convention between France and Liechtenstein which provided for the mutual exchange of information, or the Convention on Administrative Assistance to combat fraud or tax evasion. So Rambo was, on the face of the legislation, liable to pay the 3%, subject to any defence under EU law. And as we've seen, the court held there was no EU law defence. The restriction was justified, we respectfully submit, because the court accepted the submission of the French government that, and if you could go to now volume 3, tab 28, give the reference in just a minute. Paragraph 43, which is on page 1158. be looked at. Where the court accepted that, in the case before it, the French tax authorities were unable to obtain from the tax authorities of the Principality of Liechtenstein the information needed to exercise effective fiscal supervision of the information provided by the companies. Now, of course, this was legislation actually aimed at preventing tax evasion or tax avoidance. The argument of Rambo was it went too far. The French government's submission is recorded at paragraph 30 at page starts at 1156.
Sorry, paragraph?
Paragraph 30. And you see what the French government was saying, and it seems that was accepted, that the tax was designed in such a way as to deter taxpayers to seek to avoid the tax by setting up companies as the owners of immovable property in states which have not concluded mutual assistance, so no one can find out who really owns the property. The essential test for exemption is whether the French authorities can directly request from the foreign tax authorities all the information needed to corroborate the tax returns made by companies which own property rights or other rights in rem. And the next paragraph, the French government explains, well, you can read that to yourself, I'm sure, more quickly than I can read it. But the point that's put there is that in the absence of a convention containing an administrative assistance treaty, the French tax authorities were not in a position to make a request directly to the tax authorities. And of course, the reason for that was that the information that was required, essentially, was information as to the shareholding in the company, and maybe shareholding in the shareholders in the company, because there may be layers and layers of corporations put in place in order to disguise the fact that actually these were companies which were simply put up by a French taxpayer to avoid or evade payment of his wealth tax. It was in those circumstances, we respectfully submit, that the legislation such as that at issue in the main proceedings was regarded as justified. Now, the argument that's been put against us, it's in paragraph 87A, and I was quite right, if I might say so, drawn to that yesterday by Lord Reed, is the argument that what Rambo established, and now it's being said that the ex-GmbH case corroborates that, is that somehow or other what happened in Rambo was that all the principles well established in EU jurisprudence to which I've taken you up to now somehow went out of the window, and they seem to have gone out of the window without much heralding, because it was being said, well, when there's a third country involved, you sort of don't need to consider proportionality. All you've got to consider, seems to be the argument, examined at a legislative level as opposed to a case-by-case basis. And they say that that is something that was established in Rambo. That Rambo basically said, well, if you can conceive of any case where you might need to have the assistance of the authorities in a foreign state, that seemed to be the argument. If you conceive of such a case, in order to satisfy the conditions for the eligibility of a tax advantage, eligibility to a tax advantage, in this case charitable exemption, if it's in a third country, you're in all cases entitled to legislate almost without regard to any proportionality, without regard to any of the three conditions that we've seen in the way it's been formulated, in effectively every case, including in this case. And that somehow is something spelt out in Rambo. Now, the paragraphs that are relied upon in Rambo are paragraphs, for this purpose, paragraphs 45 to 51, which is just over the page from the page we were looking at, but page 1159. Interestingly, HMRC leave out of their citation to your lordships in their footnote, paragraph 44, we saw yesterday, which repeats the two or three, I would accept it's probably three conditions that we have seen in the other cases. So let's look, as if I might, carefully at what is being actually said in paragraphs 45 to 51. Paragraph 45 it's basically saying, well, you can see what it says. I won't read the paragraphs to you because to save time, I think it'd be quicker if you just read those paragraphs to yourself, because, and I did read them yesterday.
What are you saying about them?
Yeah.
Well, what we say about them is that what the court was dealing with in those paragraphs was an argument made by the Commission, relying on ELISA, to the effect that the French tax authorities should conduct a case-by-case assessment of the information provided by the company established in an EEA country. And you can see that in paragraphs 45 and then on to paragraph 40, and that was rejected, as we can see, by paragraph 46. So what it's saying in those, what the court is rejecting that submission, but we respectfully submit that it's clear from those paragraphs that it was rejecting that submission on the basis only that the French tax authorities, as regards third countries, Liechtenstein, of course, counting as a third country for this purpose, were entitled to restrict the grant of the relief where it was inevitably the case that it would not be able to verify information provided by a taxpayer without the assistance from the tax authorities of the third country, in this case Liechtenstein. And of course that is in line with their finding at paragraph 43 and what they then say in paragraph 44. And what it's explaining in our submission in those paragraphs is that two things. First of all, because member states are required truly to engage in the exchange of information provided by the directive, that's the Directive 77 to 799, and members, that's why it would apply. And secondly, a member state's inability, and this is the important point, to obtain information from another member state as a result of the application of Article 8, that's Article 8 of the directive, is a consequence of the legal framework for the exchange of information adopted by the member states. Now, Article 8, you see, there's a reference to that at paragraph 48. It's a derogation from the principle. Such provision provides for derogation, it falls to be narrowly construed. Furthermore, by virtue of the principle of cooperation in good faith, the member states are required truly to engage in the exchange of information under that paragraph. In that regulatory framework, the possibility acknowledged in ELISA that the taxpayer can produce evidence which the French tax authorities must consider thus emerges as a measure intended to prevent the limit which through the application of Article 8 has been imposed by the general system for the exchange of information from acting to the detriment of the taxpayer. Article 8 was a provision put in seemingly to benefit the taxpayer by having a derogation from the principle of information in certain circumstances not being required to be given. So, in regard to other member states, even if the French, all the information is information which the French tax authorities was entitled to have verified. But if it's information in regard to another member state, it has to give the taxpayer the opportunity of showing that the conditions attached to not being liable for this tax have been satisfied. And that was the Elisa case. And if it can't get that information, that's only because the other member state has, we can assume, acting bona fide, has relied upon Article 8. But Article 8 is something that all the member states have agreed to. And since that is a provision for the benefit of the taxpayer shouldn't suffer a detriment because the French tax authorities haven't been able, in a particular case, to gain the information that they wanted. That's Elisa. But when it comes to a non-EU country, the position is different. The court was not, we respectfully say, saying that in every case, a priori restrictions as regards third countries are justified. It was simply saying that the difference of treatments as regards third countries may justify an a priori restriction in an appropriate case. And an appropriate case was this case, where the legislation was designed to combat tax avoidance or evasion, where the information that was required was complex, and where on the face of it, that information was going to require the cooperation of the authorities of the other state in order to enable the information to be checked. Obviously, in a case like this, when you're talking about potential tax evasion or avoidance, you can't simply rely on the say-so of the taxpayer. You've got to check that information with the state, in this case Liechtenstein, and if there's no treaty for the exchange of that information, which there wasn't in the case of Liechtenstein, it would be right to conclude that that is not information which you're going to be able to get. Because, of course, the information that you're seeking is information of a highly confidential nature. You cannot expect the competent authorities to be able to divulge any of the relevant information which you need in the absence of a convention. That is all in our submission that Rambo is saying. It doesn't establish, in our submission, the point that HMRC rely on it for. It doesn't establish in our submission the point that all that a revenue, all that the member state has to say to justify legislation which absolutely prohibits an exemption, denies an exemption applying in all cases, and irrespective of the particular legislation that there is, or the conditions that need to be satisfied under that legislation for the particular tax advantage to be denied, or the tax disadvantage not to apply, all it needs to do is point to the fact that in some cases it may be necessary to get some information of some kind verified by the tax authorities of the other territory or country. It doesn't go that way. It simply shows that in a case concerning the legislation of this type in France, the need for an exchange of information agreement can be justified in the legislation in regard to a third country, even if it can't be justified in relation to another member state. It can't be justified in relation to another member state because it's put the regulatory framework as different, essentially, because as between member states, they've agreed to provide all the information. And if they haven't provided the information in reliance upon the Article 8, well, that's something that has been agreed between the member states. And taxpayers shouldn't suffer because of that inability. It must be given the chance, that's the way it's put, to satisfy French tax authorities, and legislation that doesn't give him that chance is disproportionate regarding a member state And as regards non-member states, it is justified in this case. So look, my lady, what I propose to do now is to go on to X, GmbH, because that's the next authority which is relied upon for this purpose. It is said by HMRC that this approach, as they put it, was endorsed in X GmbG at paragraphs 90 to 91. So let us have a look then at the X case, which is the very last authority in the bundles. It's tab 37 of the same volume 3. Now the question at issue in X,
That's page 1490.
1490, I'm so sorry, yes, I should have given you that. This was the most recent jurisprudence of the CJEU. Question at issue is set out at paragraphs 1, 2 and 3 of the judgments.
Well, 1490 is the Advocate General.
Yes, that's the Advocate General.
Yes, 1514
Yes.
is the start of the judgment.
Yeah. 1513. Yeah, yes. And you can see paragraphs 1 to 9. You may want to read to yourself what the nature of the dispute was, but I could summarize it by saying that the legislation which was at issue which was aimed at preventing German companies in particular from, in effect, utilizing a tax avoidance scheme to avoid tax on their available by investing or transferring their available capital to companies incorporated outside of Germany in courts with a much lower tax rate than in Germany, set up seemingly for the sole purpose of avoiding the tax, but without any genuine trading activity, to prevent that from applying. The legislation itself was quite carefully focused because it set out in the legislation a whole range of activities, if you could show that the company was doing those activities, which would justify the tax not applying. What it did was that if you couldn't do that, then the profits of that company were regarded as attributable to the German taxpayer. It arose in a context where there had been an assignment by the taxpaying company in Germany of its rights to apparently to sporting rights to a company incorporated in Switzerland, which has a much lower tax rate than in Germany. Because the idea is you then avoid, as a subsidiary set up in Switzerland, the idea is to avoid paying a higher rate of tax in Germany on that. But this is all set out in those paragraphs. And if we go to just go back, just to see what the questions were, at page 1493, there are a number of questions. 1492, there are 3 questions that were asked. I don't think we're concerned with the first 2 questions. You may look at if you want to see what they were. I think the one that's pertinent here is the 3rd question. The first 2 questions are answered in the negative. Does Article 56 preclude legislation of a member state under which the basis of assessment to tax of a taxable person resident in the member state, which holds at least 1% of the shares in a company established in another state, includes pro rata the percentage of the shareholding positive income earned by that company from invested capital, where such income is taxed at a lower rate in any member state. And at page 1502, I direct your attention to paragraphs 79 and 80, which again I'd ask you to read yourself. See in paragraph 80 that the German government submitted that what's called the incorporation rules, i.e. incorporating the profits of the foreign company into the profits of the German company, are justified by overriding reasons of public interest. Quite a few, actually. It wasn't just effective fiscal supervision. The balanced allocation of power to impose taxes, prevention of avoidance, on the basis of which it refers to the need to prevent wholly artificial arrangements. The French government added the incorporation rules may also be justified by the aim of ensuring the effectiveness of fiscal supervision. And 82 and 83, I think, are just worth looking at. See that the objective was the need to thwart wholly artificial arrangements capable of justifying restriction. And then he makes a reference to Cecil, which we looked at yesterday, and at paragraph 85, he says what his conclusions are. Says that, paragraph 85, member state entitled to rely on the objective of preventing wholly artificial arrangements. Secondly, judgment confirms scope of such and is the same as when it is relied on in relations between member states. Particular tax legislation that issue must seek specifically to prevent conduct involving the creation of wholly artificial arrangements. From the point of view that the incorporation rules provided by the legislation go beyond what is necessary to attain the objective, irrespective of whether the objective must be examined as an autonomous overriding reason. He says, well, the rules don't specifically cover artificial arrangements. And paragraphs 96 and 97, I think, are worth.
Well, what are we looking for?
How he distinguishes between relations between member states, which is the point, and relations between member states and non-member states. That's paragraph 96. You see how he does it. I'm not going to tell you on that because I'm going to go straight to the paragraphs which are relied upon by HMRC. But they obviously can't be read in isolation. They've got to be read in the context of the judgment as a whole. So could I take you first to paragraph 85, page 1525?
And this time we're looking at a judgment of
This is the
Grand
judgment.
Chamber.
This is the judgment, yes.
Five.
85. And 86 is worth just looking at as well. And when you get to paragraph 89...
I mean, are we meant to be reading this? Or what do you want?
Well, I'll leave it to you, or you could read it afterwards. We go to paragraph 89, after examining the same differences as we've seen before. It says the legislation issued in the main proceedings does not concern member states, but third countries. And then there's a citation from Rambo. And then at paragraph 91, regarding in particular, now this is one of the paragraphs which is relied on in particular member states' obligation to give a taxable person the opportunity to produce evidence demonstrating any commercial justification for its shareholding in a company established in a third country, it is apparent from the Court's case law that the existence of such an obligation must be assessed according to the availability of administrative and legislative measures permitting, if necessary, the accuracy of such evidence to be verified. And then there's reference to both Rambo and emerging markets. It's also apparent from the Court's settled law that where the legislation member state, and then there's a repetition of the threefold condition that I've referred you to before, which runs through all the jurisprudence right up to the latest one in February. So the Court is not resiling from that in any way. But this is one of the paragraphs which is relied upon by HMRC to suggest that somehow this was endorsing a radical departure from that principle, which was set out in Rambo.
Well, you would say that the principle is in paragraph 92.
Yes, and its application of that principle to a case like this is in 94, since a member state is not required to accept the information provided relating to the activities of a company established in third countries, when it's not able to verify, if necessary, the accuracy of such information. And then paragraph 95, to the extent that such a legal framework governed inter alia by treaties does not exist between a member state and third country concerned, it must be held that Article 63 does not preclude the member state concerned from applying legislation such as that at issue in the main proceedings, which provides for the incorporation, etc., without the latter being afforded the opportunity to demonstrate any commercial justification for its shareholding in the company. By contrast, if such a legal framework were found to exist, the taxable person should be given the opportunity to demonstrate, without being subject to undue administrative constraints, any commercial justification that there may have been for its investment in third countries concerned. And then paragraph 96 simply says, in answer to the question, that the legislation is not precluded, does not preclude legislation of a member state which requires income obtained by a company established in a third country that does not come from an activity of that company pursued on its own account, such as income classified as controlled company income, invested capital within the meaning of the legislation, is incorporated pro rata into the tax base of taxable persons in the member state, where a taxable person holds at least 1% shares, unless there is a legal framework providing in particular treaty obligations that empower the national tax authorities of that member to verify, if necessary, in other words, the accuracy of information provided in respect to that company with a view to demonstrating that the taxable person shareholding in that company is not the result of an artificial scheme. Because, of course, the legislation was aimed at artificial tax avoidance. It set out in the legislation a whole range of activities which it would accept are not are genuine trading activities. What it was concerned to do is to get at the phony company set up for the sole purpose of enabling the German taxpayer to avoid payment of German tax as part of a scheme. In order to see whether the company was of that sort or was a genuine trading company carrying out the activities which under the legislation would rank as genuine trading activities, obviously in the case of a non-member state, one can see applying essentially the same principle as in Rambo, although it doesn't actually endorse the Rambo in any way. I don't think there's any reference here, but one can see that what this is getting at is that the only way when you've got a non-member state to be able to find out exactly what are the activities of a company established in a third country is to get the cooperation of the authorities in that country to provide you with the relevant information. What exactly is this company doing? What are its tax returns in there? Does it have tax returns? What does it say in any accounts that it submits to you it is actually doing? Now, you can well see on that this is all very confidential information, and you can't get that information unless you have a mutual exchange of information treaty with that country. So X in our submission doesn't take the matter any further. It doesn't endorse the proposition in Rambo, which HMRC claim you derive from Rambo.
Well, it's perhaps helpful in that it's not only more authoritative, but it also, if you compare paragraph 91 of the Grand Chamber's judgment with paragraph 50 of Rambo, reading paragraph 50 of Rambo in isolation, it might be interpreted as laying down a general rule that no mutual assistance treaty, therefore no right of the taxpayer to produce any evidence required himself. Whereas paragraph 91, I think, makes it clear it's not a question of there being such a strict rule, but rather that you have to take account where necessary. If there's going to be a necessity for evidence to be verified, then you have to take into account the availability of measures which would permit such verification. So it fits better into a proportionality analysis.
The problem is they're dealing with proportionality. The principle is the same. They've all adopted exactly the same principle. It's got to be necessary. It can only be obtained from the tax authorities, and without a treaty, you can't get it from the relevant tax authority. Those are the three conditions. They have, and you've got to be able to see that on the face of the legislation, because what the court is being asked to do is, it says, this is the legislation. Is it okay? Does it comply with EU law? What the court is concluding in X is, yes, this legislation does. Its aim is to stop tax avoidance. It hinges upon whether the company is carrying out a real economic activity or is just there to avoid tax. In order to find out what the company really does, you've obviously got to do a search. You can't just rely upon the taxpayer. Taxpayer may say, oh yes, well this company is doing a very genuine, it's making films or something like that, but you've got to be able to look to see what is this company really doing. And for that you may need a lot more information concerning what the company is really doing, and you'll need the cooperation of the tax authorities. So it's perfectly legitimate for this type of legislation to be put in. For that purpose. Has no application here at all, and certainly in our submission does not justify the contention which is made by HMRC in its written case. Well, before I go off this subject, I think you were asking yesterday to have clarification as to which of the various authorities involved member states and which involved third countries. My learned junior has prepared a table. I think he's prepared a table which sets it out. I won't take you through that table.
Well, most of us have worked it out for ourselves already.
Well, even those who have may find it a useful aide-memoire.
Thank you.
Well, that concludes my submissions on that part, which is, of course, the central issue on this appeal. But, under agreement as to timetabling, I believe I have just 10 minutes of my submissions to go. Could I just make this point in relation to the matters we are dealing with? And that is that you only get to, we respectfully submit, you only get really to EU law and having to determine, for example, whether the legislation is compatible with EU law and whether anything needs to be read into the legislation to make it compatible. You only get to that where the legislation of a member state imposes some restriction which can be regarded, restriction on a tax advantage, which can be regarded as discriminating between a member state and a third country or another member state, and which therefore infringes the principle of freedom of movement of capital. So if the legislation doesn't impose any territorial restriction on a tax advantage, it cannot be infringing any principle of EU law. And of course, our case is that the second limb of section 23(6), the point I made at the outset of my submissions yesterday, for reasons set out in our written case and amplified yesterday by reference to other illustrations of the use of the same expression in the Act when referring to trusts which were undoubtedly capable of being trusts governed, especially governed by a non-UK law, that when you do that, the extension of the territorial restriction derived from Dreyfus as to the meaning of the word charities, the extension of that to the second limb, property held on trust for charitable purposes only, is not justified as a matter of domestic law. And if that's right, then you don't even get to any need to consider a modifying, conforming construction, because there's nothing to modify or conform. That part is perfectly consistent. And what the government has, the legislation I should say, has reserved for HMRC to ensure that the privilege is not abused is specifically in section 23(5) that the taxpayer has to satisfy HMRC, because it's not in dispute, the burden is on the taxpayer, that the property can only, no part of the property can ever be applied, can never become applicable, is the way it's put, for non-charitable purposes. And that is the safeguard, if you like, safety net for the HMRC. If it's not so satisfied, and it may not be so satisfied, for example, if it says, well, this is a trust governed by Ruritanian law, and we have not got any information as regards Ruritanian law that satisfies us that a trust of this sort is going to be as enforceable in Ruritania as an English trust, perhaps I should say Scottish trust, would be enforceable in England or Scotland. And if it takes that view, that there is no evidence to suggest it, the taxpayer has to prove that Ruritanian law does enforce trusts in the same way, and may not be able to prove that to satisfaction of the commissioners, of the tax tribunal. Section 23(5), it's in volume 1 on the legislation. I don't know whether you want to have a look at it again. You do, I'll give you the...
MS 370.
Yeah, it's volume 1, 370. If it can become applicable for purposes other than charitable purposes, it's a condition of the eligibility for the relief. Well, the other, I don't know whether you need to hear me anymore on that. I wasn't intending to amplify my submissions in relation to issue B. You see them in the written case. I took you to it yesterday. What we say is that HMRC, or the government's benefit of HMRC, has seemingly accepted that, because it looks as though that has a direct relevance to the second limb. Probably doesn't have much, if any, relevance to the first limb, but it certainly would have a relevance to the second limb. Because under the first limb, you've got a UK-based charity, and of course, it wouldn't qualify as a charity if it could apply, or if its property was applicable for non-charitable purposes. But under the second limb, there may be questions which the Revenue can direct their attention to. They've directed it to in this case, and they're satisfied that the Coulter Trust is as enforceable in Jersey as would be a trust in England, and I assume also a trust in Scotland, or for that matter in Northern Ireland. So there's no need for anything more. there is a need for anything more, then that has to be tailored strictly by reference to what I call the tripartite conditions, which we see coming from the repeated principle. And if you apply that here, clearly the information is not, no information is needed, certainly not in the case of call to trust, from the tax authorities of Jersey. Well, now, lady, the question of conforming interpretation, again, we set out our case in our written case. In a sense, it's a minor issue, because the real question is it justified to put in this blanket restriction, which the Court of Appeal accepted. The Court of Appeal said, well, if there's no exchange of information agreement, that's it, in all cases. If that's not justified under the principle of proportionality, then obviously conforming interpretation can't be, because it goes not only beyond what is required by EU law, we would say it goes contrary to what is required by EU law. And that conforming interpretation, actually, we would respectfully submit, is itself not justified under EU law for the purposes of any purpose of EFS in this type of case. I use that expression because we're talking about the application of the second limb of section 23(6). Of course, it has repercussions for the first limb as well. It's difficult to see how the Dreyfus interpretation of the meaning of the word charity can be consistent with EU law, though that is not directly a question that is an issue in these proceedings. It's relevant, I suppose, in this sense. You've seen our alternative argument. And again, that's in our written case, but just to explain it, our alternative argument is very simple. If we accept the conforming interpretation that was put on section 23(6) by the Court of Appeal, how does the Court of Appeal get to that conforming interpretation, one asks? And the answer is, well, it's because of the decision in the first decision of the Court of Appeal, CA1 as we've called it. If you accept that CA1 decided that the Dreyfus restriction on the meaning of the word charity should be applied to impose a territorial restriction on the meaning of the words trust for charitable purposes only in the second limb. But the Dreyfus restriction is not actually contained within section 23 at all. It's not even contained in the 84 Act, because the 84 Act defines charity by reference to its income tax definition. Of course, Dreyfus was an income tax case. Dreyfus was deciding what the word charity meant in the context of the 1918 Income Tax Act and what the legislature meant by that. Well, if that's right, then if a charity, a charitable institution, which is actually what Dreyfus was concerned with, if a charitable institution satisfies the Dreyfus test as modified by the Court of Appeal's modified, as it were, restriction to comply with EU law, i.e. another country provided that there is a mutual exchange of information agreement, then a Jersey established trust would satisfy the income tax definition of charity because under the 1952 treaty, which I think you will find in volume 1 at tab 7, I'll give you the electronic number in this one moment. 408. That was concluded in 1952, and it provides for mutual assistance and exchange of information in relation to income tax, because it was a double taxation agreement relating to income tax. So on that basis, the question arose, does, I think, a Jersey charitable institution, Jersey Hospice Care, I think is referred to in the will, though it was cut out by variation, does Jersey Hospice Care qualify as a charity within the modified Dreyfus restriction? The answer is yes, because under the 1952 treaty there was an exchange of information for income tax purposes. If it qualifies as a charity for income tax purposes, then seemingly it would also qualify as a charity under the 84 Act, because the 84 Act, far from containing any separate definition of charity, defines charity by reference to its definition in the Income Tax Acts. And on that basis, a charity in Jersey would qualify under the first limb, and therefore a fortiori, a charitable trust governed by Jersey law would qualify under the second limb, because the restriction, the extension of Dreyfus to that was simply an extension of the original Dreyfus restriction. The Court of Appeal saying, well, there can't be any distinction between the two. We disagree with that. We say there is a distinction. But if you accept the reasoning of the Court of Appeal, then that's our alternative argument, that therefore a Jersey charitable trust would qualify, actually a trust governed by Jersey law, because of the 1952 treaty. That's the argument. It's our alternative argument. It wasn't, I accept, an argument raised below, but it goes through the issues for which permission to appeal has been granted. I haven't dealt with the last issue, and I can deal with that very quickly. If there is to be a restriction of the sort that the Court of Appeal thought was appropriate, what's the time that you decide whether that restriction has been satisfied, the need for a information exchange agreement? We say that logically it's at the time when you need to have the information to decide whether, as at Mrs. Coulter's death, this was a qualifying trust entitled to exemption. You don't, of course, get that information right on the date of death. In fact, strictly speaking, it's the theoretical moment just before the date of death. You don't get that information then. You can't, obviously. It's got to be later. There are many things that happen later. HMRC say, well, that can't be right because you've got to pay your tax up front. Well, yes, you do, but and so they say if it doesn't qualify on that date of death, well, we accept it doesn't qualify the date of death, but that can be as a result of information which necessarily is obtained after the date of death. Also, Section 23 itself, if you look at some of the other conditions, you can see that there are circumstances where you cannot tell for certain whether a gift qualifies for charitable exemption until events after the date of death have or have not occurred. Furthermore, there is an ability, as pointed out by HMRC, to vary the trusts of the will, and they take effect as from the date of death. That's Section 142. And there's a like provision where provision has been made under the Provision for Family Independence Act, in Section 146. So events can happen after death which affect the amount of tax that is payable. And there's detailed provision in the 84 Act for adjusting, one way or the other, the amount of tax payable. So there's nothing in that point. It's an administrative point. You pay the tax up front on what you conceive to be the tax liability, but events later can change that tax liability. It could go up, it could go down, and then there is an adjustment one way or the other. That's our submission in relation to that, and we say that by the time, on the facts, by the time any of the assets of Mrs. Coulter's estate became vested on the trusts of the will, i.e. by that time, the Coulter Trust was clearly a qualifying trust because it had changed its law to English law and was registered with the Charity Commission. And also by that time there was a 2009 treaty had come in to effect, which provided for an exchange of information. Lords, that is my submissions. I think I've gone 5 minutes over what I'd agreed.
I think you've gone a little bit over, yes.
Yes, I do apologise to my learned friend for that. Perhaps I can make up for it by having less time in reply.
I wonder if I could...
Please, my Lord, yes.
Quite clear.
Yes.
On the question of conforming interpretation
Yes.
and how we apply the
Yes.
threefold or fourfold test.
Yes.
The test directs us, first of all, to identifying what the requirements are on which the grant of a tax advantage is dependent. Okay? Now, you've referred to the requirement imposed by Dreyfus that the body be, the charitable body be one established in the UK. Now that cannot be a relevant requirement for EU purposes, for the purpose of this discussion. It's plainly in breach of EU law, and its verification would have nothing to do with obtaining information from tax authorities in other countries. So what are we left with? The requirement that the that the property gifted become the property of charities or is held on trust for charitable purposes only. Right? Now, I'm not sure, are charitable purposes to be understood as purposes which would be charitable in UK law?
That's always been the case, yes. That doesn't involve discrimination because the court, I think in Persia and other cases, has made it clear that a national court is perfectly entitled to adopt what it wishes in terms of what charitable purposes it regards as being eligible for tax relief.
Yes.
So that's not an infringement.
And a charity, we can apply the words of the income tax statutes, a body established for charitable purposes.
Yes, a body of persons or trust established for charitable purposes only. Yes.
Right. So how do you then apply the test that we've seen, whether compliance with the requirements that we've just discussed, whether compliance can be verified only by obtaining information from the competent authorities of, in this case, Jersey?
To the second limb, that's quite easy. You can apply that directly. As regards the first limb, your lordship's right. The definition of charities, which was placed on it by Dreyfus, and which, under the Barras principle, appears to have been accepted by Parliament because they gave enactments in precise terms, cannot stand with EU legislation. It's plainly contrary to the principle.
Yes, what I'm wondering is,
yes.
if we're left then with the requirements that are met being essential, as far as this case is concerned, that the property is held on trust for what would be regarded in UK law as charitable purposes.
Yes.
Is compliance with that verifiable only by obtaining information from the competent authorities of Jersey?
Or you would say no.
Yeah. We would say no, but to both limbs, and indeed to what we would answer is that the easiest way of making this legislation totally compliant, whilst preserving for HMRC its powers to reject any application for exemption made by a foreign charitable institution whose credentials as a charity HMRC doubt, its protection for that is in section 23.5. So if you just scrub the Dreyfus restriction altogether and let the words read as they read, body of trust established for charitable purposes only, you reject, inferentially by that means, the construction of those words put upon on the court in Dreyfus. Of course, you're entitled to do anyway, but Dreyfus, even though it was approved by the House of Lords, if you reject that because it's incompatible with EU law, that one can get to that, say, perhaps a fiction, by saying that in 1984, when the Act was passed, Parliament can be taken not to, although it's used the same words, it can be it's taken to have not intended that those words should bear the same interpretation as had been put there. And you can just reject that and say, well, Section 23.5 gives HMRC the power to require the credentials of this foreign institution to be checked. And if it's not satisfied that it is truly carrying out charitable purposes, and it may be that in some cases it's not satisfied because it has been unable to obtain verification of various matters in the foreign state, it simply rejects the claim and says that under Section 23.5, the property of this charity may become applicable for purposes other than strictly charitable purposes. So that's how we would respectfully submit, the easiest way. Otherwise, you could attach to the meaning of the word charity a modified Dreyfus, but taking in the threefold conditions that we've seen in the authorities, which is more imaginative construction, although it's actually set out, because those passages, which are repeated again and again in the authorities, are almost a blueprint for what legislation has to have to justify a restriction.
Thank you.
So, unless I can assist the court any further...
Could I just clarify one thing from your exchanges with Lord Reid? The disapplication of Dreyfus to Section 23, which you advocate, would that mean, in effect, saying that Section 272 didn't apply to the extent that it imposed a restriction on the free movement of capital?
That would be, as well, the safer course, because different considerations might arise when you're talking about exemptions for income tax purposes.
But for your purposes, that would achieve the...
I'm only concerned with
that result.
Inheritance tax. It
Thank
doesn't
you.
apply...
Yes, I just wonder about that.
Yes.
In 272,
Yes.
tells us it has the same meanings in the Income Tax Act.
Yes.
Well, the Income Tax Acts tell us what a charity is. And we still need to look at that to find out what a charity is. The problem is the gloss put on that by the House of Lords in Dreyfus.
Yes.
And it's really that gloss that has to be
I think it would be open to say that gloss, certainly for inheritance tax, cannot stand up to scrutiny under EU jurisprudence. Of course, the government recognised that when it came to the 2010 Finance Act. It's actually no longer the definition of charity. And it recognised that was a... We don't accept, incidentally, that the 2010 Act, which put into effect the provision, the gloss on Dreyfus, which the Court of Appeal, in its second decision, thought should be put on it. It still doesn't extend. Well, for example, it doesn't extend to Jersey, even though Jersey has well, we've seen the 2009 treaty. But all the Act said was that for the purposes of constituting a charity, various conditions now have to be satisfied. And in regard to a foreign charity, that it's only a charity established in specified territories, which are members of the EU, and territories specified in an order, a statutory instrument made subsequent to the Act. There have been two statutory instruments that have been made. One has brought in Norway and Iceland, members of the EEA, and the other, somewhat belatedly, brought in Liechtenstein, because apparently Liechtenstein had not concluded any agreement for mutual assistance. Because there are lots of other countries or territories that have mutual assistance agreements, standard in double taxation agreements, but they haven't been brought in as charities. But at least you can see Parliament has recognised that the Dreyfus, whatever else the Dreyfus construction of charity, can't stand with EU law. I have now gone even further over my time. But
well, yeah, you were provoked, but nevertheless, you have a total time available and it can be used...
Could I just say, if I haven't dealt with a particular matter in our written case, it's not that I've abandoned it. It's simply that I haven't had time to deal with it.
That's no doubt the case. Yes, indeed. Well, do you wish to follow, Ms. Lemos? Thank you. Ms. Baker. Now, you had indented for a lot more time than the appellant did, but presumably that was because of the intervention.
Well, yes. We had revised the time estimate this morning, and on the basis of our revised time estimate, we had hoped that we would be started some 15 minutes ago at the latest. So if we
did you share your revised timetable with us?
Well, we discussed it this morning, and the idea was that we would have 3 hours today, and the appellants would have 3¼ hours. That would require Mr. Steinfeld to have finished at 11:30. He then suggested that he might require a bit more than that. So we said, well, okay, go on for another 10 minutes, which was why he said that he was supposed to be stopping at 11:40. That was the proposal. If I could just outline now how we would propose to proceed in the time that we have available, and I think it will mean Mr. Steinfeld having a bit less time in reply, but he accepts that. What we propose to do is divide the submissions between myself and Mr. Yates, who is now Mr. Yates Queen's Counsel, I should say. And what we would also propose to do is take the submissions in the order that are set out in our written case, leaving aside the third country issue that has already been decided. There are three reasons for that. The first is the point that Mr. Steinfeld made at the close of his submissions today, which we agree with, which is that if he is right on the domestic law, the Dreyfus point, then the EU law point simply doesn't arise. So we think that it's right to start with that point.
We are interested, as I put to Mr. Steinfeld yesterday, which obviously was a bit confusing, that we need to know what the requirements of EU law are before we begin to address the interpretation of Section 23.
Yes.
It may very well be, as recent exchanges have shown, that Dreyfus is irrelevant to all of this. The question, in a way, that you have to address is whether what the Court of Appeal did is justifiable.
Yes, but my lady, we are going to get to that, and it will form the meat of our submissions. But if the court would permit us, we would like to start off with the Dreyfus point lightly, because it has been addressed by Mr. Steinfeld at the end of his submissions. And as he said, it's only once one identifies what the restriction is that one then goes on to ask whether that's justified. Putting it another way, if you leave aside the Dreyfus point, this isn't a case where you look at the obligations arising under EU law and you ask whether the statute can be moulded to fit those obligations. Because in this case, without the Dreyfus point, the EU law provisions are not engaged at all, because there is no restriction on the face of the statute. And that's what my learned friend just said, and we agree with it. So in a way, logically, one has to deal with Dreyfus first, because until you have dealt with that and answered the question, does Dreyfus extend to the second limb of 23(6), unless you answered that, you don't know whether there's a restriction at all. But Mr. Yates will deal with that lightly, and we will then get on to the issues of justification and conforming construction. That's what I would propose. The other reason for dealing with that, there are two other reasons for dealing with Dreyfus first. The first of the reasons is that in order to have a meaningful debate as to whether the restriction can be justified, you need to know what restriction you're talking about. And that flows on from the point that I've just made. The last reason for starting with Dreyfus is that some of the arguments that we'd like to make on the EU law points they're set up first in the Dreyfus discussion, and it's easier to make them at that point. So we think that it somehow flows on. But we're not going to dwell on it, and we will propose to spend the majority of our time on issue C, as Mr. Steinfeld has rightly done. With the court's permission, that's the way that we would propose to develop our submissions in response, with Mr. Yates starting with B and C, and then I will deal with D, and Mr. Yates will go back to E.
It's really the end of it. Anyway, so was Mr. Yates proposing to deal with the Dreyfus point?
Yes, he was proposing to deal with it before then going on to issue C.
Well, if he would like to do that, it's not what we want to happen, but we are content to let him do that. But he should bear in mind that we've all read Dreyfus.
Yes, we have in mind very much that he's going to deal with that likely, but Mr. Steinfeld did deal with Dreyfus during his submissions this morning, and so at some point...
He did, but he did it in what we would regard as the logical order, in the end. So...
Mr. Yates is saying if it would very much assist you, he is happy to deal with C first, but he is going to have to deal with Dreyfus at some point.
Of course. But
in that case, he's content to deal with C first. We'll then get on to the other issues. As I said, I'm going to deal with D, although a lot of that will already be foreshadowed in the discussion of C, so I may not need to be very long on D.
My lady, my lords, as is apparent from our written case, the revenues say that the question of justification on the basis of effective fiscal supervision has been helpfully clarified by the Grand Chamber now in GmbH. And following that decision, our case is as follows, namely that notwithstanding that the revenue are satisfied that the call to trust in this case is for charitable purposes only, the legislation at issue here, once one extends Dreyfus to Limb 2, does not permit exemption for the relevant transfer of value to the call to trust, and EU law does not require a different result, since any prima facie restriction on free movement of capital is justified. Now, that is so regardless of whatever sympathy one has for the particular facts of this case. As my Lord Reid observed yesterday, and as we will see from the Court of Justice case law, the analysis for third countries takes place in a different legal framework, and that's not disputed, as my learned friend addressed you on this morning, compared to intra-EU transactions, and in particular, on the revenues case, permits member states' legislation to deny beneficial tax treatment without requiring that legislation to provide an opportunity for a taxpayer to be able to put forward evidence. That is our case. And as I emphasised before, that is notwithstanding the fact that there is no dispute on the facts of this case that the call to trust, leaving aside the Dreyfus restriction, was for charitable purposes only. Now, just by way of background, the revenues position in the Court of Appeal was slightly different. Before the Court of Appeal, on the second occasion, the revenue conceded that a reference might be necessary on 2 points. The first was whether Haribo, and in particular paragraphs 132 and 133, contained a rule which had to be applied before one could have the availability of justification on the basis of effective fiscal supervision. And what the revenue was suggesting was that in light of Velta, emerging markets and Cecil, that so-called rule, if it was one, didn't appear to be followed by the Court of Justice in subsequent cases. And so there was at least doubt on that point. And the second question was the one which I think we're grappling with here today, was whether on the facts, whether if on the facts the revenue are actually satisfied, whether they can still refuse relief, since one is not engaged on a case-by-case analysis. And that concession was recorded at paragraph 67 of the second judgment of the Court of Appeal. Now, if we, just by way of the outline of my submissions, you were taken this morning to the case of A, and you will recall the discussion about the so-called 3 conditions. And it might well be helpful just to turn that up, just so as to frame the terms of my submissions. So A is in volume 2, tab 26. And we just need to turn to paragraph 1096. Sorry, paragraph?
It's paragraph 63. So
it was put to my learned friend that there are three conditions really in paragraph 63. One is that the legislation is dependent on satisfying requirements. And broadly speaking here, we say those requirements are that you are either essentially a bona fide charity or a bona fide trust where you're holding property for charitable purposes only, and there is essentially no possibility of trust property or charitable property being used for any non-eligible purpose. Then moving on to 2, compliance with which can be verified only by obtaining information from the competent authorities of a third country. And we submit that the key word there is verified. What I'm going to come on to develop in my submissions is that what the Court of Justice is concerned with ultimately is whether there is a legal framework, that's using the language in ex GmbH, whether there is a legal framework by which a member state can obtain information or documents so as to verify.
Well, clearly, in the case of the requirements that we're looking at, compliance, it's not true to say that compliance can be verified only by obtaining information from the competent authorities of a third country.
Well, I see the point, my lord. I'm going to come on and meet it, if I may, by developing the case.
You simply accept that. I mean, you've just told us that the revenue is satisfied in the present case that the trust it meets the requirement.
Indeed, but
your answer is it's not a case-by-case basis, it's a legislative structure basis.
It's a legislative structure. There are clearly, and I don't think my learned friend disputes this, there are clearly going to be circumstances falling within Section 23 where the revenue do need to go and check that what they're dealing with is actually a genuine charity. It's an unfortunate feature of modern life that charity relief, like many other forms of relief, are abused.
I don't understand how the case-by-case versus blanket rule distinction enters into the test we were looking at in paragraph 63. Wherever legislation makes a grant dependent on satisfying requirements, compliance of which can be verified only by obtaining information from third country authorities. And that clearly isn't the position in relation to section 23(6), because it's been verified in this case.
The revenue are content in this case. In terms of verification, they haven't obviously had an opportunity to ask Jersey to exercise their information powers.
But you don't need to, because you've verified it yourselves.
As I say, there's no dispute on the facts of this case, but what we're concerned with here, and what ultimately the Court of Justice's case law is concerned with, is whether the legislation sets down a condition, and here it's just generally exclusive charitable purposes, just using that as a shorthand. And the revenue would obviously need the right to verify that in many situations. My learned friend mentioned yesterday Argentina or Kazakhstan. I mean, the breadth of my learned friend's case is that it's all very well, and this is a point which really comes out in Dreyfus, it's all very well looking at a jurisdiction, a familiar jurisdiction like Jersey, which has the rule of law, has, indeed, it has a rule on charity law, which is very similar to English law. But what is going to be good for Jersey also has to be good for Kazakhstan.
Well, I appreciate that, but verified only by obtaining information clearly isn't satisfied if what you're saying is it can be verified in some cases, in relation to some countries, such as Jersey, without recourse to their authorities, whereas in relation to some other countries, such as you would say Kazakhstan apparently, it does require information to be obtained from that country's authorities.
Well, I wouldn't even suggest that it would necessarily automatically apply to Jersey. I mean, you could have a fraudulent transaction going on in Jersey as well. You have fraudulent transactions obviously going on in the UK. So it's not as if you just assess, well, we know Jersey's a relatively bona fide jurisdiction, no problem at all. The revenue need to have the right to check. Because as soon as the revenue don't have the right to check, you open up the difficulty which was actually recognised in Scatterverket by the Advocate General. It might be a convenient moment just to turn back to that. So if one turns back to paragraph 133, this is page 1082. Moreover, since the taxpayer knows that such evidence cannot be checked with the authorities of the country in which the distributing company is established, the member state concerned faces an increased likelihood that its legislation will be infringed. So it's all very well, let's move away from Jersey, let's just consider a third country. The taxpayer puts forward information saying, I'm a bona fide charity. On the face of the documents, etc., that looks all well and good. But the taxpayer knows that the revenue have no realistic way of checking that, other than, and this is the point raised by my learned friend, other than putting them to proof ultimately, perhaps in a tribunal case. But if the revenue can't have a corresponding check on that information, the ability for the revenue to challenge what appears to be prima facie valid evidence essentially goes away. That's the real concern in this case. And ultimately, that's on our interpretation of the Court of Justice case law. That's why you do have these blanket rules. It's not because you go through each case and weigh up whether you're actually happy, even though you haven't got an independent means of verifying. If you don't have an independent means of verifying, you don't have to give the relief. And then, if I can just return back to 63, because there is then the putative third condition. The expression, it proves impossible to obtain such information from that country. Well, what we say about that is that really isn't an independent condition. One isn't asking the question whether the revenue, in the absence of a legal framework, it isn't asking the question of whether, if it asks nicely to the United States or to Jersey, if it wouldn't mind terribly passing on the information, notwithstanding there's no legal obligation for the tax authority of that third country to do so, whether that stops the revenue being able to rely on justification. As we will see from the case law, as I hope to develop in my submissions, what the Court of Justice is ultimately concerned with, and is helpfully clarified in X, is that if there is a legal framework, the taxpayer does have to be given an opportunity to put forward evidence, because that can then be verified. If there isn't that legal framework, it is as stark as the legislation can have that blanket restriction.
I mean, on its face, paragraph 63 of Scatterbaquet would allow a case-by-case approach, but you say further case law supports your proposition.
Indeed.
Yes.
You're coming to say which one?
Or
give me your best case, which says that.
Well, my best case is X.
It's X.
X.
Yes.
So really, we can look at X and not bother about all that.
I won't be looking at as many cases as Mr. Seinfeld. I will have to look at Rimbaud and emerging markets and Cecil just to deal with some points in reply. But yes, we say X has produced clarity where previously there was at least some uncertainty. But if I can, if I may, I can just deal with some other points which Mr. Steinfeld relied on in relation to Scatterbaquet now that I'm here. There are 2 points really. If we go to, first of all, yesterday, Mr. Steinfeld took you to paragraphs 129 of the Advocate General's opinion. That's page 1081. And again, this just emphasises the point. If you pick it up just by G, the question is therefore whether such an exclusion based on the premise that evidence supplied by the taxpayer cannot be checked with the competent authorities of the country of establishment can be regarded as proportionate. You then see at paragraph 130 that the Advocate General thinks that that premise is made out, i.e. Sweden doesn't have the right under its agreement with Switzerland to ask for that information. What the Advocate General then records is that the Swedish tax court thought that, on the contrary, that it was possible, but it's those comments which then inform paragraph 131, to which you were taken to yesterday, because what the Advocate General is assuming is not the is essentially the absence of a legal framework. He is not assuming that the Swedish tax authority, in the absence of such a framework, have tried and failed on a gratuitous basis, as it were, to ask the Swiss authorities for help, and that's been refused. He's not engaging with that assumption. He is just recording the debate going on at 121 and 129 and 130 as to whether there is a legal framework. And then we come on to the comments which over the page at 133, which I've already taken you to. And then the other comment which you were taken to this morning is paragraph 154. Which I accept on its face is unhelpful to the case which I am seeking to persuade you of. And I would make 3 points in relation to that. The first is that formulation has never been, in my submission, expressly followed by the Court of Justice. Secondly, it's my Lord Hodges' point that this is now, given the subsequent developments in the case law, an old case in any event. And in particular, we have to consider the fact that we now know, especially from Rimbaud onwards, that it's not a case-by-case analysis.
I think that's the same as point 2, essentially. Subsequent.
Indeed. The one other point I think it's worth just recognising as to why the revenue were able to satisfy themselves of this case is the relatively peculiar history of the call to trust. Because as you all know, when set out in the will, it was a pure Jersey law trust. What then happened was there were 2 deeds of variation. The first essentially gave the trustees power to bring the call to trust into line with the requirements of Section 23, which it was held by Mrs. Justice Rose, and this issue hasn't been pursued, wasn't sufficient to bring it within Section 23. Because, as you're aware, under 142, Section 142 of the 1984 Act, which my learned friend referred to today, it's possible to have a readback within 2 years of the date of death to vary the will. And what the revenue accepted before Mrs. Justice Rose was that if the will had been varied so as to stipulate English law as opposed to Jersey law, because of the fiction created by the 84 Act, i.e. reading back that change into the will, that would have been sufficient to satisfy Section 23. Regardless of EU law, that's just as a matter of domestic law. That variation failed. There was then essentially a second attempt, which definitely did change it into English law, but that, for reasons which I don't need to go into, the case law has held that you only get one bite at Section 142. You can't vary a variation. And in any event, it was outside the 2-year time limit. So what then occurred was that the call to trust then essentially shifted its residence to England and also registered with the Charity Commission. So I just want to, and this is all alluded to at paragraph 68 of my learned friend's written case, but I just want to emphasise how peculiar, relatively speaking, the facts of this case are, and why the revenue, for various reasons, was able to satisfy itself that there was going to be no point about this was a bona fide charity.
But none of that, none of those points of the variations makes any difference to the revenue's understanding of Jersey law, because the net product of those variations is 0 in terms of tax consequence. Therefore, you're thrown back onto your understanding of Jersey law.
In terms of Jersey law, as to whether that wouldn't permit, for example, a variation to a non-charitable purpose, I accept my Lord Hodges' point. What the issue about verification, and I'm going to come on because I'm going to have to come to Persia, what the issue about verification is in relation to charities is, notwithstanding that you might have a formal document, the tax risk in relation to a charity is not that the formal documents don't quite add up, because as my Lord Hodge has pointed out, you can read the document. The risk is actually that you're dealing with a sham or a fraud or something like that, where on any view Parliament isn't intending that relief is going to be given, but there is obviously a risk that it might be given. So, just returning to my submissions, as I said, before the Court of Appeal, there were 2 points of doubt. One was, is there a rule in Haribo? And secondly, whether on the facts of the case, that if the revenue are satisfied, they can still refuse relief. And those are ultimately, in some ways, the same points before you today, albeit we say that both of those points have helpfully been clarified by XG and BH. Now, I'm going to start with Haribo because my learned friends still, as I understand it, seek to sustain an argument on that. And so if we can take up Haribo and turn to volume 3 at tab 29. That's page 1161. So, just by way of signposting, the key point from Haribo is that on one reading of paragraphs 132 to 133, it appears that the Court of Justice were ruling that before one could avail oneself of a justification that there was an absence of an information sharing agreement, the legislation itself had to expressly make favourable tax treatment depending on the existence of such an information exchange agreement. Now, as it happened, that was in fact the position in the two preceding cases, Scatterverket and Rimbaud. And it was also partially true, contrary to what my learned friend said yesterday, it's partially true for Haribo itself. And if one just takes up the judgment, you can see the legislation set out at page 1199, paragraph 4. And so this is paragraph 10 of the German law, sorry, Austrian law. And if one looks...
On page 1199.
1199?
Paragraph 4, thank you.
Yes. And if one looks down at item 6, sub-paragraph 6 of the passage set out, you can see that one has exemption if you are in the EEA, but only if you've got both procedures for mutual assistance with regard to administrative matters and enforcement. So what the legislation was seeking to do was put the beneficial tax treatment on two conditions. One is that you could get information, and the other is you could actually enforce a tax debt, potentially in that country. And what we'll see, the passage you were taken to yesterday at paragraph 75 was dealing with the EEA situation. And ultimately what the court said was information's fine, the enforcement is excessive, it's disproportionate, you don't need that. But then there's a separate situation under legislation where if you weren't in the EEA, you just didn't get the exemption at all. And that's what paragraphs 132 to 133 are dealing with. One other curious feature of the legislation is that if you look down at sub-paragraph 2, you did get exemption essentially for any company, whether in the EEA or in a third country, provided you held a 10% stake. And this is ultimately, I think, in my respectful submission, what Lady Justice Arden was getting at, namely that it is actually hard to understand how justification could be attempted, because what the legislation was saying, that there were obviously some carve-outs in subparagraphs 4 and 5, was saying that if provided your stake is big enough, we don't really care whether there's an information sharing agreement or not, which one would have thought would have fatally undermined.
Thought it might have been the reverse.
Yeah, indeed. And this is actually a point made by the Advocate General, but is ultimately not followed, and that's just for your note, that's paragraphs 99 to 102, but it ultimately is not really followed by the Court of Justice. So when we come to just setting up paragraphs 132 to 133, that is answering the question for the non-EEA countries, and the question posed is at paragraph 105 of the Court's judgment, which is on page 1217. And you'll note that it's referring to both, initially there was a threshold of 25%, and that was then reduced to 10%. But that's the provision I'm referred you to earlier. And then you can see at paragraph 107, the situation for what I might call true third countries versus EEA countries is set out. And then we come on to the key passage, which is really starts at paragraph 129 on page 1220. And then and in particular, the passage at 131 to 133, with the key bit being 132, because the national legislation doesn't provide for any exemption, etc., etc., etc.
Sorry, what are you saying about that?
Well, that is the apparent rule, and then what I'm going to show you is how that rule essentially hasn't ever been followed since. And that is despite, we'll come to 4 cases. One is Velter.
Well, the apparent rule is in 131.
131.
Yes.
But
then they're actually answering a completely different question, which is about whether it's justifiable to have this discrimination between people according to the size of their shareholding. Is that right?
No.
Right.
That is one way they could have dealt with it. But what they actually, I'll rephrase that. On the face of the judgment itself, that is not a point they're taking. That appears to be the reasoning behind Lady Justice Arden's dealing with this particular provision. What I'm going to be submitting is you don't really have to resolve that question, because what I'm going to be demonstrating is that in 4 subsequent Court of Justice cases, where this rule should have been applied if it were a rule, it hasn't. It hasn't even been mentioned.
Sorry, which rule? Rule are you now talking about?
The rule that because your national legislation does not provide any exemption is dependent upon
I see.
a mutual exchange agreement. It's got to be expressly in your legislation. And I obviously accept that on the face, Section 23 doesn't have such conditionality. And so therefore I had to deal with this. Leaving aside, before I get on to the question of substantive justification, am I barred by this essentially procedural rule before I get to that? I say such a procedural rule doesn't exist at all. I will go on to demonstrate that, and then obviously also satisfy you on substantive justification. And so if you see, just for your note, at paragraph 82b of our written case, before the Court of Appeal, we pointed out that any so-called rule had been ignored in 3 cases, which were then available. Those were Velter, Emerging Markets, and Cecil. And again, for your note, you'll see in the footnote at paragraph 39 footnote 39 of our written case, we set out where exactly in those judgments the legislation is and the reasoning of the court. But ultimately, in all 3 of those cases, and as we'll come on to see, also in XG and BH, there was just a blanket rule without mentioning an information exchange agreement. And at least whilst Velter justification failed for other reasons, at least in relation to the other cases, namely Emerging Markets, Cecil, and as we now know, XG and BH, justification was essentially made out, subject to some points of clarification. The gist of the submission is that, as the court is probably well aware, the Court of Justice rarely expressly overrules itself. So the submission, to borrow from Oscar Wilde, is that to overlook a so-called rule once may be regarded as misfortune, but 3 or 4 times looks like an implicit departure or ignoring of the rule, or possibly that no such rule existed in the first place. So that is obviously, of course, before we come to XG and GmbH, and we now say that that is helpful. But in each of the latter 3 cases, the point I want to make is that the Court of Justice has ignored Haribo despite citing other paragraphs of the judgment in its reasoning. And again, I don't need to go through all of the cases, but just by taking XG and BH as the last one, Haribo is cited at paragraphs 55, 60, 72, 83, and 92 of XG and BH, but not paragraphs 131 to 133.
Yeah, one could say the same, I think, about the critical paragraph in Rambo. From memory, 55. I don't think that gets cited either.
Oh, well,
it's
paragraphs
paragraphs that do.
I'll I'll come to that, but I believe that paragraphs 45 and 46
Oh,
of
yes, they're
RAP
cited.
are indeed cited by the Court of Justice and the next GmbH. So, if I may, I'd first like to turn to Persia because that is the case on charities where the Court of Justice does recognise this justification for third countries. I will then go to Rimbaud, Emerging Markets and Cecil to deal with my learned friend submissions, and then I'm going to turn to ex-GmbH. That is how I plan to do my submissions. So if I may, I'd like to turn to Persia, which is in volume 3 again.
And can I just ask what at the end of the day, what's the objective here? Is the objective to persuade us that we should read into Section 23 some scheme of conditionality on the existence of a mutual assistance treaty?
No, my lord.
No.
The revenues case is that, particularly following X, if it can be shown that justification is made out, there is nothing wrong with Section 23 on this case, and you don't need to conform it at all.
Justification for what?
Apologies,
Justification of what?
justification on the basis of effective fiscal supervision.
Well, Haribo, they were looking at the justification for a legislative provision which imposed a condition that there should be a mutual assistance treaty so far as portfolio shareholdings were concerned. And the problem in our case is we don't have any legislation or your problem in our case is we don't have any legislation imposing a requirement of that kind.
Well, if I can just deal with that in two parts, my lord.
Yeah. So that's what there was the question was, could that legislation be justified? That was the issue in Haribo. But in our case, there's no question of justifying legislation along those lines because there isn't any.
Well, my lord, what we're seeking to justify is Section 23, sub 6, on the revenues interpretation
The revenues
as a matter of domestic
interpretation,
law,
which includes Dreyfus.
which includes Dreyfus on limb 2.
Yeah.
And so we're seeking to justify a restriction, essentially a jurisdictional restriction on the trust.
To the UK.
Yes.
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 All right.
It's clearly what they're trying to do.
To the EU countries, you can't restrict it.
Well,
Court of Appeal.
this is a point my learned friend is going to be dealing with, but in Hurst, well, if you take X and the Hurst case, you only have to attempt conforming interpretation where you're satisfied there's been an infringement of EU law. And what X says is if the taxpayer is in a country where there's no legal framework, to use the language of X, if the taxpayer is in such a country, it can't complain of any infringement of EU law. That is our case. And so our primary case on conforming interpretation, once we make out justification, is you don't need to do it. It's only, the issue of conforming interpretation really only arose in relation to the Court of Appeal because it wasn't clear that, whereas it is now, it wasn't clear that the so-called rule in Haribo wasn't a rule. And this issue had been run before in a case called BT Pension Scheme, which my learned friend Mr. MacDonald appeared in, and he took the Haribo point. And I'm not going to go to that case, but the upper tribunal in that case said, well, we'll just read in, as a matter of conforming interpretation, this conditionality, and that satisfies Haribo.
If we understood you correctly, your primary case is that Section 23, interpreted in the light of Dreyfus, applying to both limbs of the definition, is perfectly okay. There's nothing wrong with it.
Is perfectly okay
Yes.
vis-a-vis a third country which doesn't have an information exchange agreement with the UK.
You say it's perfectly okay. So, in a limited sense, presumably you've got a fallback, which is that if you fail on that, the Court of Appeal solution is
Indeed,
correct.
my lady, but and my learned friend will be dealing with that in due course.
So I just wanted to clarify what it was you were seeking to justify.
So if I may, could I turn to Persia, and that's behind volume 3, tab 27. And so very briefly, the German legislation set out at paragraph 6 was essentially a very similar condition to Dreyfus. So it's paragraph 6 of the Court of Justice, that's page 1124.
Sorry, could you just repeat that number, please?
It's paragraph 6 of the Court of Justice, page 1124. It's also summarised by the Advocate General at paragraph 10, that's on page 1104. But essentially, you only got relief if the relevant body, the relevant charity, was a body established in Germany. So it is almost exactly what the Dreyfus restriction is. And it's important to note that this is an income tax relief case, as opposed to an inheritance tax, and it's also an intra-EU movement of capital. And again, just engaging with the point raised this morning with my learned friend, the Court of Justice held that it's permissible for a member state to decide what constitutes a charitable purpose. That's at paragraphs 44 and 48. That's on page 1130. But it was held that the restriction, the German establishment restriction, couldn't be justified for intra-EU transactions, and that's paragraphs 51 to 69, which you've already been taken to. That's pages 1131 to 1134. But then we come to 70, again, which we set out in our written case. That's on page 1134. As regards charitable bodies in a non-member country, it must be added that it is, as a rule, legitimate for the member state of taxation to refuse to grant such a tax advantage, if in particular that non-member country is not under any international obligation to provide information. It proves impossible to obtain the necessary information from that country, and then A is cited. So this is in a context, actually, this is the point I really wanted to emphasize from Persia, where the German legislation is essentially a very similar restriction to the one which is before you in this case. But what the Court of Justice is highlighting is, in the context of that German legislation, which only had two conditions, a bit like ours, charitable purpose as defined by German law, and it has to be a body established in Germany, you could make out justification. At least it wasn't, it was broadcasting that as a general observation at paragraph 70. If we then can move on to Rambo, that's the same bundle following tab 28, page 1136. You will see that from the Court of Appeal's second judgment that the revenue relied heavily on this case below. And as my learned friend Mr. Steinfeld has already alluded to, this case involves the same legislation as that considered in Elisa, but also coincidentally in Prunus as well. It gets looked at 3 times by the Court of Justice. And those 3 cases concern 3 situations. One is intra-EU, vis-à-vis Luxembourg, that's Elisa. One is intra-EEA, and that's Liechtenstein in this case, Rambo. And then the third country situation with the BVI in Prunus. Now, there's no real analysis of justification in Prunus because they find that Article 64 is satisfied. So the 2 cases are both to consider are really Elisa and Rambo. And what the Court of Justice decided was that the justification of effective fiscal supervision wasn't available for intra-EU transactions, that's Elisa, but was available vis-à-vis Liechtenstein. And one would assume that would also extend to third countries, but as I said, Prunus doesn't actually comment on it in detail. And as my learned friend has already said, the purpose of this legislation, which isn't really described in Rambo or Prunus to the same extent, but it is mentioned by the Advocate General in Elisa at paragraphs 11 onwards, that's, just for your notes, that's 2109, was to essentially disincentivize natural persons in France seeking to avoid French wealth tax by sticking a property in a foreign company. And what the legislation did was impose a flat 3% annual charge on the commercial value of property unless you fell within various exemptions. And that essentially was the location and value of the properties and the identity of the members. And as the Court of Justice records and if we just move on now to page 1158, as the Court of Justice records at paragraphs 41 to 42, there was no information sharing agreement with Liechtenstein, and the 77 directive didn't apply either. But when one then looks at paragraph 38, the court contrasts the position in Elisa, where the taxpayer was to be given an opportunity to provide the information on its shareholders. And it's worth just noting here, contrary to what my learned friend has suggested, that simply providing the identity of taxpayers is hardly a detailed sort of multifactorial inquiry. There will obviously be share certificates which could be proffered, and that is what the court is envisaging in a case such as Elisa. Because one of the oddities about Elisa was that in Luxembourg, the Luxembourg authorities weren't actually permitted to get hold of this information. And because of Article 8, which I'll come on to briefly, allowed that exception to the 77 directive, what the Court of Justice said was, well, the fact that it's actually impossible for the French authorities to actually get this information, to verify this information with the Luxembourg authorities, whilst obviously very unfortunate, isn't enough in an intra-EU circumstance to justify refusing the relief. But what we see in Rambo is obviously in a third country situation, obviously the position is radically different. So we do come to paragraphs, well, first of all, I'd like to just take you to paragraphs 40 to 43, because my learned friend took you to this yesterday.
And am I right in thinking this is another case where what's an issue is whether legislation restricting the tax exemption to situations where there was a bilateral tax convention with a third country was justifiable? It's a restriction specifically concerned with the existence of tax conventions that had to be justified.
Yes, so it wouldn't breach, for example, the so-called rule in Haribo. But what was also that's the procedural sort of contingency. But what had to be verified, if one looks back at the legislation, I don't propose to take you back, but what had to be verified and essentially signed by a declaration was the identity of the properties and the identity of the shareholders. So that was the ultimate, that's the substance of what the French government were after, or the French legislation was after. And what they said is, if you aren't within a country with an information sharing agreement, you don't even get the chance to give us that information. We're just going to deny you relief. But if you are in a country which does have that information sharing framework, then you provide us this information and then you don't get caught by the 3% tax. That's the gist of it. And what were the facts of Rambo were obviously that there was no information sharing agreement. So even if the taxpayer wanted to proffer the information, the legislation says, well, you're still going to get the 3% tax. And ultimately what we will see is the Court of Justice says, well, that's fine. Thank you. And if we just turn, if I could just turn to paragraphs 40 to 43, I think my learned friend, Mr. Steinfeld, yesterday suggested that 43 was a sort of finding of fact that the French authorities just couldn't, by hook or by crook, get any information from the Principality of Liechtenstein. In my submission, the key word in 43 is accordingly. That has to be underlined, because that is essentially referring back to paragraphs 40 to 42, which are concerned solely with the absence of a legal framework. They're not concerned with attempts by France to approach Liechtenstein and essentially being rebuffed. And if one thinks about it, it would be surprising if the French had bothered, because their legislation says you don't get relief because you're not in an eligible country. So it would have been surprising if the French authorities had actually investigated that. Now, so we say 43 isn't a sort of finding of fact or a sort of fact sense. The French have tried but failed. What 43 is doing is just setting out that because there is essentially no legal framework, the French authorities are unable to obtain. So it's looking at it from a framework rather from a sort of realistic access point of view.
I wonder, I mean, a point you'll need to address at some stage is this. In this case, we can see what the restriction is. It's on page 1153, that in paragraph 7 sets out Article 990E, paragraph 2, legal persons having their seat in a country or territory which has concluded with France a convention on administrative assistance to combat tax evasion and avoidance. And so that's a restriction that's held to be proportionate. Now, what you're trying to justify is a restriction which confines relief to bodies established in the UK. And you're trying to justify that restriction on the basis that a restriction in the form that we see in this French case would have been justifiable. You appreciate the difference?
I do.
You've got to bridge that gap.
So there are 2 points ultimately wrapped up with the French legislation in Rambo. First is the Haribo point, but I'm going to go through and just demonstrate that that is no longer a good rule. So it's just coincidence, as it were, in the French legislation. The second point is that what the restriction is the denial of essentially beneficial tax treatment. The restriction isn't the contingency itself. That's just the means by which you go about denying the key relief. The key restriction is you have to pay Rambo has to pay 3% tax on the market value of its property in France. And that's discriminatory because, on the face of it, because someone in France doesn't have to do that. A legal company in France. So that's the restriction. The restriction in this case is that we are denying inheritance tax relief for a transfer of value to the call to trust. Because we say the call to trust isn't a UK governed trust, UK law governed trust. And whilst I take my Lord Reid's point that the legislation in Rambo is different because it expressly links beneficial tax treatment to having an information exchange agreement, the revenues case is that is, in the light of subsequent case law, no longer a relevant factor. And we see that in particular in relation to emerging markets. We see it in Cecil, and we see it in X. So we then have paragraphs 45 and 46, which you've already been taken to. I'm not going to ask you to read that again. But what I think is also worth just highlighting is paragraphs 48 to 50. So you were taken to this morning, and what they're talking about is essentially the scope of the 77 directive and the limits which are put on that by Article 8, which I've given you the reference for that already, but that broadly said that if Member State A asks Member State B for information and Member State B can't, as a matter of its own internal law, ask for that information, then Member State B isn't found to be in breach of the directive for failing to supply it. So it's essentially recognising the fact that different Member States will have different information powers for their tax authorities. So that's what the derogation is. It's nothing at all to do with the justification itself. And what they're actually having to grapple with is that in ELISA, there was actually an impossibility for the French government to actually get this information from Luxembourg because the Luxembourg authorities themselves weren't able to get it. But it's still saying, notwithstanding that, because it's inter-EU and for all the policy reasons to do with that, the French government still had to give relief. And then we come to 50, because what 50 is talking about is the existence of the right to essentially put forward or have the opportunity to put forward evidence. So when we come to 50, it says, although therefore that possibility is based on the existence of the general system for the exchange of information, the existence of a right of that kind, so that's a kind to provide information, in the case of a taxpayer in circumstances such as those of the case before the referring court, which are characterised by the lack of, and here we go, any obligation on the tax authorities of the Principality of Liechtenstein to lend assistance. So again, this is what I'll be saying when we come to all the cases. What the Court of Justice is actually concerned with is a legal framework, a legal obligation to provide information. It is not looking and doesn't care about attempts by member states outside of a legal framework to give it their best shot to get information but from some other means. And then 51, we come on to essentially the ultimate conclusion that the legislation is justified. If I may then, I should be able to deal with emerging markets and possibly Cecil just before the short adjournment. So if we take up emerging markets, that's tab 32. Now, I think the key point, which I want to, sorry, that's page 1299, my lady.
Yeah.
The key point, I think my Lord Hodge asked my learned friend yesterday, was whether paragraph 84 of this judgment assisted my learned friend, and that's on page 1336. And so that says, it follows from the foregoing that the justification based on the need to maintain the effectiveness of fiscal supervision can only be accepted where the legislation of a member state makes entitlement to a tax advantage dependent on the satisfaction of conditions, compliance with which can be verified only by obtaining information from the competent authorities, etc., of a non-member state. So in our case, we say the legislation does make the obtaining of a tax advantage, that is, relief from inheritance tax, dependent on the satisfaction of conditions, that is, the conditions set out in section 23, and in particular, on the facts of this case, section 23, sub 5 and 6, compliance with which can only be verified by obtaining information from the competent authorities of a non-member state. And we say that's also the case here because insofar as the revenue feel the need to verify in dealing with a foreign body, they obviously, so take a simple situation here, call to trust, nothing's happening in the UK at all. The only possibility is to obtain information from a foreign tax authority. And as I set out in our, as we set out in our written case, the information which a foreign tax authority might be able to provide isn't simply restricted to the niceties of tax returns, etc., etc. We set out an example, the case of Derin, where in a sort of mirror provision, where the revenue have gone after bank accounts and other such information from third parties on behalf of a foreign tax authority. And we set out in our written case again that, by way of example, the Jersey Information Exchange Agreement also contains such provision. So in essence, if Jersey doesn't itself have that information, it has to use its own powers from other people on the island to obtain that information, i.e. from people not necessarily connected with the taxpayer. So what we are concerned about is verification. And will the revenue, in every single instance, insist upon and require verification in relation to a foreign body, assuming that relief is prima facie due. I'm sure that's not going to be the case, but they do need to have the power to do so, and that is ultimately what the Court of Justice is addressing. And again, if we come on to paragraph 85, we can see that, again, the distinction is drawn for the situations where there isn't a regulatory framework. So that's what the Court of Justice is addressing, if you see there just above C. The question is, there does exist a regulatory framework of mutual assistance, and then the only question the Court of Justice then asks, under 87 and 88, is whether, and this is going to be a matter for the referring court, whether under that framework there is in fact power to ask for this information. That is the sole parameter, really, of what the Court of Justice is asking. It is not asking for whether Poland is going to make an approach to the United States outside of a legal framework to try and get that information in any event, let alone provide the taxpayer an opportunity to just proffer it itself.
But in all these cases, the court is looking at legislation which imposes a restriction which is plainly designed to enable, to ensure that information can be obtained when necessary to verify that the relevant relevant requirements are met. I mean, the difficulty you're facing, as I see it at the moment, is that it's basic to proportionality analysis that the restriction imposed has to be logically related to the aim being pursued and no greater than is necessary for the achievement of that aim. And that's basic proportionality. Presumably you accept those propositions.
Indeed, but with one clarification, which I think is not disputed by my learned friend, that the analysis of proportionality in intra-EU transactions, which after all is virtually every transaction under the treaty, apart from Article 56, one always has, to borrow a term from English public law, anxious scrutiny about exactly has the member state calibrated things just right, has it stepped over the mark. When one comes to third countries, as we see time and time again, the Court of Justice says, with third countries the legal framework is different. And essentially the Court of Justice is handing out far blunter tools to member states to deny relief. And the proportionality analysis we will see is much cruder.
Well, the question is whether it's quite crude enough for your purposes, because what you're trying to rely on is a restriction which is not related to the purpose that you're using as your justification, in the same way as, for example, the French legislation was in Rambo, but is simply a crude nationality-based discrimination, and plainly is far more sweeping in its ambit than a restriction directed specifically to the existence of a TEIA, as the French legislation was.
Well, what we say is that the restriction we have in Section 23, namely the requirement that the trust has to be essentially governed by UK law, is pursuing an objective of effective fiscal supervision, because we require essentially the trust to be to properly regulated. To some extent, this point does crop up a bit in Dreyfus, which might inform the justification analysis, but and we can see also a flavour of that when Parliament later enacts amending legislation in FA 2010. Again, the concern is about you are subject to the jurisdiction of a proper court, and also in addition, if there is a regulator, you also comply with that regulatory regime for charities. So, my Lord, we do say that we do have a proper restriction, and it is pursuing an aim recognised by EU law. Ultimately, the concern of Section 23, and it may well be that it's opportune to turn to it after the short adjournment, ultimately Section 23 is deeply concerned that relief which goes to charities or attaches to property which goes to charities isn't misused, and therefore the draftsman goes to great lengths to deny relief if there is essentially any possibility that, for example, that property could be used for private means.
I entirely accept that, and you could go further and say that Dreyfus was concerned to ensure that that bodies benefiting from the tax exemption were indeed properly regulated charities, and it acted on the assumption that only a British court. Only a British court's jurisdiction could meet that objective. The problem for you is that while that may have been the underlying rationale of Dreyfus, to confine the exemption to British established charities nowadays is more sweeping than the justification accepted in Rambo and these other cases would support, which is simply a restriction to not necessarily Britain, but a country which had a tax information exchange agreement with Britain.
Indeed, my lord. But
Perhaps you'd like to think about the answer to that, because it's time we adjourned, and you might want to choose your words with care.
I'm grateful, my lady.